Good morning. 2 years ago, the Department of Justice brought criminal charges against FedEx. The charges involved FedEx's picking up and delivering packages for internet pharmacies that, according to the government, were illegal. We went through a 6-year grand jury investigation. After indictment, we went through 2 years of pretrial proceedings. Defending this case cost millions of dollars. The trial started this year on June 13th, and it was expected to be a 3 to 4 month trial with 80 will call witnesses and thousands of exhibits. After 2.5 days of trial, it was over. The government voluntarily dismissed all charges. The court declared FedEx to be, quote, factually innocent. The United States Attorney's Office in the Northern District of California has an ongoing investigation, internal investigation, as to how this could have happened. You know, I could spend hours talking to you about this lawsuit because FedEx experienced every problem that could happen with an overzealous prosecution. During our 8 years of experience, during our 8-year experience, we were involved in the following: a grand jury investigation that lasted 6 years. They're trying to use a non-prosecution agreement to force us to change our business practices and to pay millions of dollars, tens of millions of dollars. Prosecutors and supervisors who were totally myopic and never once looked at the facts or considered if we had a defense. They were seeking fines and penalties of $1.2 billion. This was designed to get a big media splash, but these damages were totally unsupported by the facts or the law. In the time I have, I want to give you some idea of why the court called this a novel prosecution from day one. It's clear to me from our experience that overcriminalization problem requires solutions. First, let me tell you a little bit about the government's charges. The Department of Justice's basic claim was that FedEx distributed prescription medications that were, quote, dispensed outside the ordinary course of professional practice and not for a legitimate medical purpose. What this really was based on was the practice of internet pharmacies using an online questionnaire that consumers filled out in order to get drugs sent to them, prescription drugs, and not seeing a physician or talking to a physician personally. The government claimed that FedEx was, and I quote from their opening statement, a part-time drug dealer, and this drug courier should be treated in this court like Your Honor would treat any other drug courier. As we pointed out in our opening statement, FedEx must be the worst drug dealer in the world in all of history because we put our drug dealers in uniforms with our names on their coats. We send them out in trucks with our name emblazoned in huge letters on the side of the truck. Just before trial, it was interesting to us that the Department of Justice entered into a $100 million exclusive contract for transportation with this drug dealer. Before trial, the court asked the government about its novel legal theories. And I say novel because the court used that term over and over in just about every proceeding that we had before the case began. At one pretrial hearing a year before trial, the court asked the government if there had ever been a single prosecution, not a civil case, but a criminal prosecution, of a legitimate common carrier for the illegal distribution of drugs. The government was ordered to file a brief listing all of the cases that fit that description. The brief contained not one case that fit the description because there weren't any. Incredibly, at that point, it still didn't cause anyone on the government side to look at this case and say, maybe we should step back and take a look at this. The government also charged us with money laundering. That claim was based on, or the indictment claimed that when FedEx delivered these drugs to somebody cash on delivery, and the recipient handed us a check, a COD check, which we then sent to the shipper, which is a feature of our service that we have had for many, many years, that constituted money laundering. Again, the judge was interested in that. We had Judge Charles Breyer, who, by the way, is the brother of Supreme Court Justice Stephen Breyer. He stated that he had been on the bench for 20 years and he had just never seen a drug case in which money laundering was a charge. He said, this is how it usually works. The person delivers the drugs, the other person gives the person money, and that's the drug deal, but there's no money laundering charge. And again, he asked the government to let him know of any case in which that charge had been brought. Again, the government came up with not a single case. One of the cornerstones of the government's case was an allegation that on at least 6 occasions, FedEx was in meetings with the DEA officials and other law enforcement officials, and the government claimed that at these meetings, FedEx was warned to stop doing business with these illegal online pharmacies. It was the 4th paragraph of the indictment. And of course, this was what was picked up by media. Many of the early articles, right at the time of the indictment, vigorously reported that despite being warned by the DOJ, FedEx continued to deliver online pharmacy packages. The only problem was that claim was totally false. FedEx was not warned. In fact, what went on in these meetings was actually the exact opposite of what the government claimed. The government told us that the law on internet prescriptions was very unclear, and they wished that they had a clearer law to follow. The government told us that they didn't want FedEx to do anything that would compromise their ongoing investigation. At that point, they were watching several online pharmacies, which we knew about, they were telling us about, and they were making test shipments using FedEx and other carriers. And we were told that the DEA we told them that if they would only tell us who these illegal shippers were, we would stop shipping for them. We told them on many occasions, give us one name, give us a list, we will close those accounts the day you give them to us, and we will not ship for them again. The government consistently refused to do that and told us that they couldn't because they might be sued if they did that. In fact, the 2 highest-ranking DEA officials who attended these meetings were going to testify at the trial for us, for FedEx. So we outlined their testimony in our opening statement, and that testimony was how well FedEx cooperated with all of them and how they never told FedEx to stop shipping, but instead asked them to cooperate in the investigation. Over the years, the DEA and other investigating agencies sent us hundreds of subpoenas. In fact, we helped them many times write the subpoenas, telling them where and who to send them to, and we would be glad to answer them. In responding to the subpoenas, we told the government about every shipment that was made by these pharmacies. Again, we must be the worst drug dealers in the world if we're telling the DEA about the shipments. These subpoenas instructed us on the face of the subpoena not to let our customers know that they were under investigation. And some of these subpoenas, including the ones that involved the pharmacies that were supposedly our co-conspirators under the indictment, said, quote, "This is just an investigation and your customer is entitled to the presumption of innocence." These are among the reasons that the case dissolved after just 2.5 trial days. One other reason is that every single pharmacy listed in the indictment as our co-conspirators were licensed and relicensed by the government to operate. Our co-conspirators, the judge found, were licensed and actually relicensed during the investigation, which caused the judge to ask the government, you have said that FedEx and the pharmacies are responsible for some deaths that occurred because of the overdose of drugs. The judge said, I want you to brief why you, the government, is not responsible for these deaths because you're the ones that licensed them and let them continue to practice. It should be noted that the licenses are actually signed by and are given out by the Department of Justice. I also want to say, though, that we were fortunate. FedEx has leadership and a board that was committed to fighting this case because the allegations struck at the very core of what it means to be a common carrier. We can't be in our business if we have to examine every package and make certain that every person who ships with us is following every law that they should. After all, packages with legally prescribed drugs and packages with drugs that are not legally prescribed sound the same. They look the same. And if we open the packages, we wouldn't even, which we would not do, we wouldn't even be able to tell if there had been a doctor that saw the patient before the drugs were sent out or not. We were also fortunate to have great lawyers. We had Judge Breyer, who from the very beginning was so suspect of the case. And we were fortunate enough to have the resources to fight against this for 8 years. But what happened to us could and does happen to others who are maybe not so fortunate. The most frustrating thing is we did everything we should have done. We wrote white papers, we gave them to the U.S. Attorney and the DOJ, we met with the lead prosecutors, we met with supervisors, we met with the U.S. Attorney herself twice, and even met with Washington DOJ, even though it took us repeated requests to get the meeting. None of this kept us from being indicted. So rightfully, the U.S. Attorney's Office is now doing an internal review, and we hope it leads to reform. But if not, we, through the chamber, through ILR, need to take some action so that this does not happen to others. There are a lot of things that we can do to prevent it, including not letting the money that is recovered either from agreements to settle or from trial go to the U.S. Attorney offices or to the local DEA. Again, we need to be very active in this and prevent this in the future. Thank you.